Sharon Kin, also known as Jeanette Pergolese and La Pistorella in Mexico, and Deirdre Grace D. Glabus, later Deirdre L. in Canada, was an American murderer, suspected serial killer, and prison escapee who was convicted in Mexico for one murder and is suspected of two others in the US, one of which she was acquitted at trial. She was the subject of the longest outstanding arrest warrant for murder in the history of Kansas City, Missouri, and one of the longest outstanding felony warrants in US history. While her case is officially closed, authorities still seek information about her movements after 1969. Sharon Kin was born Sharon Elizabeth Hall on the 30th November 1939 in Independence, Missouri, to Eugene and Doris Hall. The family were devout members of the Reorganized Church of Jesus Christ of Latter-day Saints, now known as the Community of Christ, a denomination of the Latter-day Saint movement. When she was in junior high school, her parents moved the family to Washington State, but by the time she was 15, they returned to Missouri. In the summer of 1956, then aged 16, she met James Kin, a 22-year-old student, at Brigham Young University while attending a church function. The couple dated regularly until James returned to BYU that fall. Sharon, reportedly deeply interested in finding a partner with prospects who could take her away from independence, wrote a letter to James claiming that she was pregnant by him. James took leave from the BYU and returned to Independence, where he married Sharon on the 18th of October 1956. Their marriage license falsely identified Sharon as being 18 and a widow. Although she later refused to address why that was there, Sharon told people at the time that she had been married when she lived in Washington to a man who later died in a car accident. The new couple held a second, more formal wedding the following year at the Salt Lake Temple in Salt Lake City, Utah, after Sharon had completed the process of joining the Church of Jesus Christ of Latter-day Saints. After the wedding, they returned to Provo, Utah. James resumed his studies at BYU, but put them on hold again at the end of 1956's fall semester. The couple returned to Independence, where they both took jobs. Sharon babysat and tended shops, whilst James worked as an electrical engineer at Bendix Aviation. Although Sharon claimed to have miscarried the child that had brought about their marriage, she soon became pregnant again. In the fall of 1957, she gave birth to a girl the couple named Dana. Sharon was reportedly a lavish spender who expected finer things out of life, but on James's salary they lived first in a rented home next to their parents' residence, then in a ranch-style house they had built at 17009 East 26th Terrace, Independence. James worked the night shift at Bendix, and Sharon filled her days with shopping and later other men. By the time the couple had had their second child, a boy named Troy, Sharon was carrying on a regular extramarital affair with a friend from high school named John Baldiz. In early 1960, James was contemplating divorce, partially because of Sharon's spending habits, and particularly because he strongly suspected her infidelity. He spoke to his parents about the possibility of divorce the day before his death, telling them that Sharon had agreed to give him one if he allowed her to keep the house, gave her custody of the couple's daughter, and paid $1,000 in alimony. James' parents, devoted Latter-day Saints, urged him to stay in the marriage. Sharon also was thinking about ways out of the marriage, according to Baldiz. She once offered him $1,000 to kill her husband, or find someone that would, although he later claimed that she might have been joking. According to Sharon, on the 19th of March 1960, at around 5:30 p.m, she heard a gunshot from the direction of the bedroom in which James was sleeping. Entering the room, she found her 2.5-year-old daughter, Dana, in the bed next to her father. Dana was holding one of James's guns, a high-standard .22 pistol, and James was bleeding from an apparent gunshot wound at the back of his head. Sharon then called the police, but James was dead by the time the ambulance carrying him arrived at the hospital. Police were unable to recover any fingerprints from the well-oiled grip of the pistol, and the paraffin test for the gunshot residue was not performed on either Dana or Sharon. Multiple people, including family and neighbours, told police that James had often allowed Dana to play with his guns, and in a test by investigating officers, Dana proved able to pull the trigger on a gun matching the one that had killed her father. With no evidence to the contrary, investigators ruled the case as an accidental homicide. The pistol that killed James was taken into police custody and never returned to Sharon. Despite her efforts to reclaim it, she later had a male friend secretly buy her a .22 caliber automatic pistol. When a friend told Sharon that he had registered the gun in her name, she requested that he re-register it under a name other than hers. With the investigation into his death closed, James was buried and Sharon collected on his insurance policies, valued at about $29,000, $230,000 in present day. Patricia Jones, born Patricia Clements, was one of 6 children born to Mr. and Mrs. L. McClement of St. Joseph, Missouri. After graduating from Benton High School, she married Walter T. Jones Jr., her high school sweetheart. Walter enlisted in the United States Marine Corps shortly after their marriage, and the couple relocated to the West Coast during Walter's service. After he received his discharge, the couple returned to Missouri and settled in Independence with their 2 children. By 1960, almost 5 years into their marriage, Jones was working as a file clerk for the Internal Revenue Service while her husband was a car salesman. Despite his marriage and children, Walter reportedly had a wandering eye. On the 18th of April, Walter met Sharon when she bought a Ford Thunderbird from his dealership using the insurance payout from her husband's death. The two began an affair shortly after. Sharon viewed Walter as a prospect for a second husband, but he was uninterested in leaving Patricia despite difficulties in their marriage. When Walter declined to join her on a trip to Washington State in May, Sharon reluctantly went with her brother Eugene instead. Although they reunited on the 25th of May, the relationship became fraught when Sharon told Walter that she was pregnant with his child. Instead of responding with what Sharon expected to be an agreement to divorce Patricia, Walter simply ended the affair. According to a later testimony, on the afternoon of the 26th of May, Sharon contacted Patricia at her office and told her that Walter was having an affair with Sharon's sister. Sharon then met Patricia that evening to discuss the matter further before dropping her off near the Jones residence. After Patricia failed to return home that evening, Walter filed a missing persons report with police and the next day began calling people he thought who might have seen his wife. He got a lead when he spoke to one of Patricia's friends who carpooled to work with her. They told him that Patricia had reported receiving a phone call that day from an unnamed woman who wanted to meet with her. She had asked the carpool driver to drop her off at a street corner in Independence, which he had done. The occupants of the carpool had seen a woman waiting for Patricia in another car, but they didn't recognize her. They nevertheless provided a description of the unknown woman to Walter. Suspicious of the identity of the woman based on the carpool's general description, Walter called Sharon and asked if she'd seen or spoken to his wife. Sharon allowed that she had seen Patricia that day. She had met her to tell her about Walter's affair. According to Sharon, she last saw Patricia when she dropped her off near the Jones residence, speaking to an unknown man in a green 1957 Ford. Based on her admission over the phone, Walter met with Sharon late Friday evening and insisted she give him more details about where his wife was. He later admitted to going as far as holding a key to her throat threateningly. Sharon's response was, after leaving Walter, to call Baldies and ask him to help her search for Patricia. Shortly before midnight, within hours of her conversation with Walter, Sharon and Baldies found the body of a woman in a secluded area approximately 1 mile outside of Independence. According to Baldies, he had been the one to suggest searching that area in which they encountered the body. It was a spot to which they had often gone on dates before. The body, dressed in a black sweater and yellow skirt, was soon identified as Patricia's. She had been shot 4 times by a .22 caliber pistol. Although the fatal wound was a shot to the head, entering near her mouth in an upward trajectory, she also had one through-and-through bullet wound to her abdomen and 2 penetrating gunshot wounds to her shoulders on a downward trajectory through her body. Powder burns on the hemline of her skirt, which had been raised to her waist, indicated that the gun had been fired from close range at least once. Initial reports and investigation placed Patricia's time of death at approximately 9 p.m. on the 27th of May. She was buried on the 31st of May. Investigators immediately began to question Sharon, Walter and Baldies. All 3 were questioned on the 28th of May. Walter and Baldies both gave written statements admitting that they had dated Sharon and both agreed to lie detector tests. Sharon gave an oral statement to police but declined to sign a written one or take a lie detector test. She was questioned again on the morning of the 30th of May and Baldies on the 31st of May. The scheduled lie detector tests for the 2 men were performed on the 1st of June and both men were deemed to have been truthful in their statements. Sharon's brother Eugene was also interviewed on the 31st of May, but declined to answer questions. While police questioned potential suspects and witnesses, other investigators focused on processing the crime scene. Repeated attempts were made to find the murder weapon and the bullet that had passed through Patricia's body, including the sifting of dirt at the crime scene and the deployment of a troop of Boy Scouts. A .22 caliber rifle slug was eventually found buried in the ground where Patricia's body had been found, providing evidence that at least some of the wounds had been sustained at the place where her body was found. Although investigators went as far as to drag the bottom of nearby bodies of water, the gun that had shot Patricia, assumed to be a .22 caliber pistol, couldn't be found. Buildings near the crime scene were also searched for blood and gunshot evidence, in accordance with the police's theory that Patricia had been attacked elsewhere and then transported outdoors. Found in her hair was initially believed to be a trace evidence of some other crime scene area, an idea that fueled the search of nearby buildings but was later determined to be fly eggs. Sharon was arrested at her home for Patricia Jones's murder at around 11 p.m. on the 31st of May, the same night as Patricia's funeral. The same day, the Jackson County Sheriff requested that prosecutors considered a second charge of murder, this one for the death of James Kinn. Sharon's lawyers, Alex Peebles and Martha Sperry Hickman, filed a writ of habeas corpus with the court that next morning, and a hearing that afternoon resulted in a release on a $200,000 bond, which she awaited a preliminary hearing originally scheduled for the 16th of June. Police were able to rule out the .22 caliber pistol that had killed James as the murder weapon in Patricia's death. That gun was still in possession of the sheriff's office. However, a man who worked with Sharon admitted having secretly purchased a new .22 caliber pistol at her request in the beginning of May. Police were unable to locate the gun in question when they searched her house, though they did find an empty box which they believed to have once held a gun. Sharon at first claimed to investigators that she'd lost the gun on a trip to Washington, then stated simply that the gun had just disappeared. Walter was taken into custody on the 2nd of June as a material witness to the case and was freed the same day on a $2,000 bond. The initial autopsy performed on Patricia was criticised by police and prosecutors, who felt that the recovery of bullets and testing of stomach contents should have been done. Dr. Hugh Owens, who had performed the autopsy, argued that he had recovered one of the presumed 3 bullets present in the body, and that because the body had been prepared by an undertaker prior to autopsy, any chemical tests on the stomach contents would have been useless. Owens did add when asked that he had not seen any food apparent in the stomach at autopsy. Patricia's body was exhumed on the 17th of June in order to collect the bullets that had been left behind at the original autopsy, as well as to gather what samples of tissue and stomach contents were possible. Sharon's arraignment on the 11th of July resulted in denial of bail, but the Missouri Court of Appeals struck down the ruling days later based on the prosecution's reliance on circumstantial evidence. She was freed on a $24,000 worth $188,976 in 2013 bond on the 18th of July. After a delay in her trial date due to her advanced pregnancy, Sharon gave birth to a daughter named Marla Christine on the 16th of January 1961. Although charged with both murders, Sharon was tried separately for the 2 crimes. The trial for the murder of Patricia Jones began in mid-June 1961, with jury selection beginning on or about the 13th of June, and the trial commencing days later with an all-male jury. Opening arguments by both prosecution and defence set up cases based on purported times of death, basing their assertion on pathologists' given testimony that Patricia had died about 6 hours after she ate lunch on the 26th of May. The prosecution claimed that Jones had died more than 24 hours before Sharon and Baldis found her body. Defence attorneys argued that the death more likely occurred 6 to 8 hours prior. Prosecutor J. Arnott Hill cited testimony by Walter Jones and Chief of Detectives Lieutenant Harry Nesbitt as evidence of Short's motive for the crime. Nesbitt recalled statements by Sharon that she was afraid Walter was drifting away from her despite the financial support she offered him, and Walter testified that Sharon had told him that she was pregnant by him and he had thereafter attempted to end the relationship. The prosecution was unable to firmly establish that Sharon owned or had once had the weapon that killed Patricia, though both Sharon's known pistol and the one that fired the bullets that killed Patricia were .22 caliber weapons. Roy Thrush, the man who sold the pistol to Sharon's male friend, had led police to a tree that contained where he claimed to be the bullets that he had fired from that pistol. However, when the bullets were extracted from the tree trunk, tests showed that the extracted bullets were not identifiable as having come from the weapon that killed Patricia. The prosecution rested its case on the 21st of June after calling 27 witnesses. Sharon's defence, which took less than 2 days and involved 14 witnesses other than Sharon who didn't testify, focused on breaking down the state's claims of motive and means, arguing that she had no reason to kill Patricia and that the pistol she was alleged to have owned had not been proven to be the murder weapon. After slightly over 1.5 hours of deliberation, the jury, citing just too many loopholes left in the prosecution's case, acquitted Sharon Kinn. Immediately after the delivery of the verdict, juror Ogden Stevens asked Sharon for his autograph, which she was photographed given to him. Sharon was returned to jail the same day to await trial for the murder of her husband. Despite her acquittal of the murder of Patricia Jones, Sharon remained charged for the murder of her husband James Kinn. When jury selection began on the 8th of January 1962, Hill announced that he didn't intend to pursue the death penalty in this case. The prosecution's case rested largely on their contention that Sharon had been so interested in seeing her husband removed that she'd been willing to pay for his murder, supported by the grand jury testimony of Balditz. Balditz, though nominally a witness for that prosecution, weakened his testimony on the stand during the trial by claiming that Sharon's offer to pay him $1,000 in return for James's murder could have been a joke, and Hill was forced to attack his own witnesses' credibility. Further prosecution testimony alleged that the Kinns' marriage had been on the verge of dissolution at the time of James's death, and that Sharon's adultery had been a cause of this, and that Sharon had known that she would collect her husband's $29,000 life insurance policies only if she was still his wife. The defence, led by attorneys Hickman and James Patrick Quinn, focused on the circumstantial quality of the prosecution's evidence, noting that prior police investigation had determined James's death to be obviously accidental, and that the jury was obligated to assume innocence on the defendant's part, no matter how unpleasant they found her moral character to be. The defence too attacked the reliability of Balditz's testimony, calling him a poor mixed-up kid who would sign anything. Kinn's attorneys also presented testimony from witnesses supporting the viability of the theory that Diana had shot her father, including statements that gun had been regularly left within her reach in the family home, that she was able to pull the triggers on toy guns with stiffer trigger pulls than the weapon that caused James's death, and that she'd often been observed pretending to fire guns in play. The trial ended in conviction on the 11th of January after 5.5 hours of deliberation. In April of the same year, Sharon was formally sentenced to life in prison. She began to serve her sentence in the Missouri Reformatory for Women. Later interviews with jurors from the trial revealed that 3 or 4 ballots had been taken before the guilty verdict was reached, beginning with the jury solidly divided and moving progressively towards unanimity for conviction. One juror told Kansas City Star that Sharon's morals had not been considered an issue at the jury, and that she thought no juror had been aware of her previously being tried for the murder of Patricia Jones. Despite the verdict, James's family continued to believe the best in their daughter-in-law, telling reporters on the day of the verdict, and Sharon herself told reporters that she felt the verdict was a mistake and that she regretted her previous enthusiasm for having women on the jury. The following week, Sharon's lawyers requested that she be released on bond, supported by a community petition signed by 132 supporters of her innocence. The motion was denied on the basis of first-degree murder not being a ballotable offence. Presiding Judge Tom J. Stubbs also counselled Sharon's lawyers that he felt their involvement in such a petition at a time when a motion for bond was being considered highly improper. A subsequent defence motion requested that the conviction be vacated because the jury had delivered its verdict based on summarised and speculation rather than substantial evidence, listing a series of procedural errors that Sharon's counsel alleged had taken place before and during the trial. These included juror taking incomplete notes, disputes over Balditz's testimony, and an incorrect number of potential jurors being provided for the selection. The motion was denied by Judge Stubbs in April 1962, but appealed to the Missouri Supreme Court, which in March 1963 reversed the conviction and ordered a new trial on the basis of Sharon's defence having been denied adequate peremptory challenges during the jury selection in her trial. Sharon was denied an opportunity for bail in 1963, but that ruling was overturned in July when she was released on a $25,000 bond posted by her brother Eugene. The state's request that the Missouri Supreme Court reconsider its position on Sharon's conviction was granted, but in October 1963, that hearing resulted in further grounds being found for a new trial, this time on the basis of the prosecutor having been allowed to cross-examine a prosecution witness. A second request for a rehearing on the validity of the conviction was denied by the Missouri Supreme Court. Sharon and her children moved in with her mother and awaited the start of the new trial. Sharon's second trial for the death of James Kinn began on the 23rd of March 1964. A jury selection got underway that day. The public was initially barred from the proceedings, but the restriction was soon loosened and journalists were allowed into the courtroom. An unusually long jury selection process made the first day of the trial last 14 hours, beginning at 9 a.m. and not ending until nearly midnight. Presiding Judge Paul Carver noted that due to the notoriety of the case, he'd been forced to choose between sequestering the entire jury pool overnight or forcing the court into a long day. The eventual jury, all men, were immediately sequestered, but days later a mistrial was declared after it emerged that the law partner of the prosecutor, Lawrence Shepard, had once been retained by one of the jurors. Sharon's third trial in the death of her husband, originally scheduled to begin in early June 1964, began instead on the 29th of June. Assistant Prosecutor Donald L. Mason declared at a jury selection that he intended to death qualify the jury, a process in which a prosecutor preemptively challenges any juror who automatically opposes the death penalty, and jury selection once again took more than 12 hours in one day. Baldy's testimony in this trial remained contradictory as to whether he believed Sharon's $1,000 offer to have James killed had been intended seriously, but he added that at the time of his death, Sharon had asked that Baldus not tell authorities about her offer. A new witness, a female acquaintance of Sharon's, testified that she had once joked that the woman should. But defense cross-examination highlighted inconsistencies between this testimony and a similar quote that the woman had offered at a previous deposition. For the first time at any of the trials, Sharon took the stand on the last day of this trial to issue a categorical denial of all charges. The all-male jury deadlocked 7-5 in favour of acquittal in this trial, resulting in a second mistrial. A fourth trial was scheduled for October 1964, however in September, Sharon, still free on her $25,000 bond, travelled to Mexico with her alleged lover, Francis Samuel Pergolese, leaving her children with James's father and travelling as Pergolese's wife under the name Jeanette Pergolese. The couple later said that they had gone to Mexico to get married. Under the legal terms of her bail, Sharon was permitted to leave the country, but her contract with the company that posted her bond prohibited her from leaving Missouri without written permission from the company's agent. After crossing the border, Sharon and Pergolese registered at a local hotel, Hotel Gin, again as husband and wife. Sharon, saying that she felt unsafe in a foreign country, bought a pistol, which meant that the couple now possessed multiple guns, having bought one or two with them from the US. On the night of the 18th of September, Sharon left the hotel without Pergolese, either to acquire money because the couple had been running low or to get the medicine she required. She encountered Francisco Paredes Ordonez, a Mexican-born American citizen, at a bar and accompanied him back to his room in Hotel Lavada. According to her account, Sharon went with Ordonez to see photographs he offered to show her, but he soon began to make sexual advances toward her, and she was forced to fire her gun at him in an attempt to protect herself. Sharon maintained later that she had no intention of harming or killing Ordonez, and that she intended only to frighten him, but her bullet stuck him in the chest and killed him. Responding to the sound of gunfire, hotel employee Enrique Martinez Rueda entered the room. Sharon fired again and hit Rueda in the shoulder. Wounded, Rueda fled the room, locking Sharon inside, and called police. Police, rejecting Sharon's story, theorized that she had gone out that evening intending robbery and had chosen Ordonez as her victim. When he resisted her orders to give her his money, police believed that Sharon had simply shot him. Police responding to Hotel Lavada arrested Sharon on charges of homicide and assault with a deadly weapon. She maintained that she hadn't intended to harm Ordonez and that she had fired her weapon at Rueda because she feared that he too was coming to attack her. Police searched her purse, finding a gun with 50 cartridges, and then the couple's room at Hotel Gin, where they found 2 more guns and another supply of cartridges. Authorities took Pergolese into custody at the Hotel Gin, initially holding him without charge and later filing charges of entering the country illegally and carrying an unlicensed gun. The gun found in the couple's room later that night was later proven through ballistics to be the same gun that killed Patricia Jones in 1960. But because Sharon had already been acquitted of that crime, she could not be charged again for it based on the new evidence. Pergolese was held at the Palacio de Lecumberri in Mexico City, where she was initially placed in the women's prison before being transferred to Lecumberri for her trial. The couple were arraigned on the 26th of September and held for trial. In October, her Mexican attorney, Higino Lara, filed a recurso de amparo, similar to a writ of habeas corpus asserting that the Mexican government was violating her constitutional rights by holding her for a shooting committed in self-defense. The request was denied, and both Sharon and Pergolese were tried in the summer of 1965. Pergolese, cleared of all the charges against him, was deported to the US, but Sharon was convicted on the 18th of October for the homicide of Ordonez. Despite rumours that she would receive probation and be deported like Pergolese, she was instead sentenced to a 10-year prison term for the murder. When she was officially notified of the sentence the next day, she asserted that she would appeal her conviction. However, the appeal backfired, and instead of overturning her sentence, it lengthened it. The three-man Superior Court that heard the case overturned one aspect of her conviction, charges of attempted robbery, but upheld her murder conviction and increased her sentence to 13 years, saying that the original sentence of 10 years had been too lenient. Sharon was returned to the women's prison to serve her sentence. There she was nicknamed La Pistolera, the gunfighter, a nickname subsequently adopted by the Mexican press. On the 7th of December 1969, Sharon was not present for her routine 5 p.m. roll call at the Iztalapan prison where she was serving her sentence. Her absence was not officially noted until she also failed to show up at a second roll call later that evening. The news of the escape was not reported to Mexico City police until 2 p.m. the following morning. A manhunt was then organised, initially focusing on the northern Mexican states due to authorities' belief that she may have been heading for the last known whereabouts of a former inmate whom she'd grown close with while they were in prison together. The search also encompassed countrywide transport hubs and eventually circled back to the Mexico City area. US authorities, including the FBI, were also alerted of Mexican authorities' belief that she may have been attempting to work her way back into her native country, but the FBI noted that it was unlikely to have jurisdiction in the case. Initial police speculation was that Sharon had bribed guards to look the other way while she escaped the prison. An unusual blackout had been reported at the prison on the evening of and at the approximate time of her escape. Investigation showed that the door that should have been locked had been left unsecured. Further questioning of prison guards and administration showed that oversight of the prison was generally lax and that it was staffed by fewer guards than it should have been. News reports of the time reported numerous theories about her escape, including that she had bribed prison guards, that she may have enlisted the help of a supposed boyfriend who was a Mexico City policeman, that her mother had been involved in the escape plan, that a former Mexican Secret Service agent had assisted in the escape, and that Sharon may have disguised herself as a man to escape. A more recent theory incorrectly speculated that the Ordonez family had helped her escape and then killed her. The intensive manhunt for Sharon was short-lived. By the 18th of December, the Mexican Secret Service and the Mexico City District Attorney Office were both reporting that they were no longer involved in the searching for the escaped prisoner, while the Federal District Attorney was reporting that responsibility for the hunt belonged to the City District Attorney's Office. Investigators speculated that Sharon had already fled to Guatemala, lessening the purpose of a Mexican manhunt. They noted that she was fluent in Spanish after her years in a Mexican prison, and that she could therefore get along rather well in nearly any Spanish-speaking area of the world. Despite vowing to keep the case open and their investigation running until Sharon was back in custody, authorities were forced to admit by the end of December 1969 that they had run out of investigative leads to pursue. Sharon's arrest and conviction in Mexico had implications for the status of her Missouri legal entanglements. Because she was being held in Mexico on the 26th of October 1964, the scheduled date for her fourth trial in the murder of her husband, her $25,000 bond was revoked on that date. Although the United Bond Insurance Company, which had posted the bond, argued that paperwork irregularities rendered the insurance of a bill illegal, the court ordered the company to forfeit the bond. Sharon was reportedly concerned about the monetary implications of this forfeiture. "I could always use the money." At Alice, Oklahoma, Times Democrat quoted her as saying, "I don't intend to spend my life in jail." A $30,000 stupendous bond was issued in August 1965 as the United Bond Insurance Company continued to dispute the payment of her original $25,000 bond. The bond allowed the company to defer payment of the $25,000 bond until a ruling on the matter was handled by the Missouri Supreme Court. But when that court upheld the bond's forfeiture, the $25,000 bond was paid to the state of Missouri in October 1965. The United Bond Insurance Company later filed the suit against Sharon's family to recover the cost of the bail, lawyers' fees, and manhunt for her after her escape. Shortly before her scheduled Missouri trial date, her Missouri counsel filed a motion to change the venue of any eventual fourth trial in the death of her husband, claiming that news coverage of the case had so prejudiced residents of Jackson County against Sharon that it would be impossible for her to get a fair trial there. When she failed to appear for the fourth trial, a warrant was issued for arrest in 1964. It was still outstanding at the time of her death, making it the oldest outstanding murder warrant known to exist in the Kansas City area. Her status in the Mexican system also remained outstanding, though authorities pointed out at the time of her escape, jailbreak was not a crime under Mexican law, and if she was recaptured there, she would only have to serve the remainder of her outstanding sentence. Kin as Deidre Glaber stay unknown. In December 2023, the Jackson County Sheriff's Office and the Kansas City Police Department both received an anonymous tip that Sharon had been living in the town of Aber, Alberta, Canada, approximately 121 miles southeast of Calgary, under the alias of Deidre Glaber, nicknamed Dee. Under Canadian law, law enforcement agencies were allowed to obtain fingerprints from deceased persons with criminal records. However, because Deidre had no such record, Canadian police were unable to do so. However, the local funeral home which had handled her remains provided a service preserving fingerprints as mementos for loved ones, which were processed through a company coincidentally based in Independence, Missouri, in the very jurisdiction where Sharon's criminal warrants remained in effect. Jackson County investigators subsequently secured a warrant to obtain Deidre's fingerprints, which were conclusively matched to Sharon's by the FBI. U.S. authorities publicly announced these findings on the 17th of January 2025. Sharon married her second husband, James Thomas Glaber, in LA in February 1970, 2 months after her jailbreak from Mexico. The couple relocated to Tabor in 1973, where they operated a motel and later a real estate agency. Advertisements of the latter business showing Sharon's picture were printed in local newspapers. How Sharon was able to obtain a travel visa, identification, and citizenship, despite her status as a fugitive, remains unknown. On the 11th of August 1979, at the age of 38, Glaber died from complications related to diabetes and alcoholism. Sharon was left out of his will, an omission she fought in court. She later married her third husband, William Willie L., in March 1982. L died on the 7th of April 2011 at the age of 79. Sharon herself died of coronary artery disease on the 21st of January 2022 at the age of 82. With Alzheimer's disease being listed as a contributing factor on her death certificate. Both her death certificate and headstone falsely record 1940 as her year of birth. Sharon left behind one son from a marriage to Glaber, in addition to her 3 children in the US. Little is known about all of Sharon's movements following her prison escape. In Tabor, she performed volunteer work, including serving as a chairwoman for a daycare center steering committee, and was known for needlepoint artistry and playing bridge. While the news of Sharon's death officially closed the case, as of 2025, authorities are still seeking details about her life after 1969. In a segment of the Investigation Discovery series, Deadly Women, covering the case author James Hayes speculated that Sharon committed her first murder for monetary gain, hoping to cash in on James' life insurance policy, and that she began to derive pleasure from killing at that point. Former FBI profiler Candice DeLong supported this assertion, stating that Sharon was a sociopath, lacking in remorse and empathy, and therefore had no compunction about killing to get what she wanted. This idea was echoed by some of those involved in prosecuting Sharon. Even those who believed in her guilt, however, said that she had a certain appeal, describing her as rather attractive and admitting that they grew to like her. The Mammoth Book of True Crime describes her as a relative rarity, a pretty criminal. In I'm Just an Ordinary Girl, The Sharon Kin Story, Hayes asserts that Sharon was inspired to kill her husband by a magazine article she read about Lillian Chastain, a Virginia woman who shot her husband during an argument and blamed the gunshot on the couple's 2-year-old daughter. Charges against Chastain were filed in February 1960, weeks before James's death. Robert Durst was a convicted murderer, suspected serial killer, and American real estate heir. The eldest son of New York City real estate magnate Seymour Durst, he garnered attraction as a suspect in the unsolved 1982 disappearance of his first wife, Kathleen McCormack, and the 2000 murder of his longtime friend Susan Berman, and the 2001 killing of his neighbour Morris Black. Acquitted of murdering Black in 2003, Durst didn't face further legal action until his participation in the 2015 documentary miniseries The Jinx led him to being charged with Berman's murder. Durst was convicted in 2021 and sentenced to life imprisonment without parole. He was also charged with McCormack's murder shortly after his sentencing, but he died in 2022 before a trial could begin. His conviction for Berman's murder was automatically vacated upon his death because his appeal was still pending. Robert Allen Durst was born in New York City on the 12th of April 1943 and grew up in Scarsdale, New York. He was the eldest son of real estate magnate Seymour Durst and his wife Bernice Herstein. His paternal grandfather, Joseph Durst, was originally a Jewish sailor from Austria-Hungary and immigrated to America in 1902 and eventually became a real estate manager and developer, founding the Durst Organization in 1927. Robert's three younger siblings were Douglas, Tommy, and Wendy Durst. When Robert was 7, his mother died by suicide by jumping from the roof of the family's Scarsdale home. He later claimed to have witnessed it, asserting that moments before her death, his father walked him to a window from which he could see her standing on the roof. However, in a March 2015 New York Times interview, his brother Douglas denied that Robert had witnessed the suicide. As children, Robert and Douglas underwent counselling for sibling rivalry. A 1953 psychiatrist report on 10-year-old Robert mentioned personality decomposition and possibly even schizophrenia. Durst attended Scarsdale High School, where classmates described him as a loner. He earned a bachelor's degree in economics in 1965 from Lehigh University, where he was a member of the varsity lacrosse team and the business manager of the student newspaper, The Brown and White. Later that year, he enrolled in a doctoral program at the University of California, Los Angeles, where he met Susan Berman, but eventually withdrew from the school and returned to New York in 1969. He then opened a small health food store in Vermont in the early 1970s. He closed the store in 1973 when his father convinced him to return to New York. In 1992, due to Robert's inappropriate conduct, his father broke with tradition and appointed his second son, Douglas, to take over the Durst Organization. As the firstborn, Robert felt entitled to run the company, despite his disdain for it. He claimed that Douglas had stolen what was rightfully owed to him, leading to Robert's estrangement from the rest of his family. He eventually sued for his share of the fortune and was bought out of the family trust for $65 million in 2006. In late 1971, he met dental hygienist Kathleen McCormack. After just 2 dates, he invited her to share his home in Vermont, where she moved in January 1972. After his father pressured him to resettle in New York to work at the Durst Organization, the couple returned to Manhattan, where they married on the 12th of April 1973. At the time of her disappearance, McCormack was a medical student in her fourth and final year at the Albert Einstein College of Medicine in the Bronx, hoping to become a pediatrician. She was only a few months short of earning her degree. She was last seen by someone other than Durst on the evening of the 21st of January 1982, where she appeared unexpectedly at a dinner party thrown by her friend Jibret Najami in Newtown, Connecticut. Najami noticed that Kathleen seemed upset and that she was wearing red sweatpants, which Najami found odd, as McCormack never dressed so casually in public. After receiving a phone call from her husband, McCormack left for a cottage in South Salem, New York. Although the couple was known to have fought that evening, Durst initially maintained that he had placed his wife on a commuter train to New York City at Catanoa Rail Station, had a drink with a neighbour, and had spoken to his wife at their Manhattan apartment by telephone later that evening. "That's what I told police," Durst said. "I was hoping that would just make everything go away." He subsequently admitted that he went home and went to bed. The two women were supposed to meet up the next day at the Lionsgate, a Manhattan pub. When Kathleen failed to appear, Najami grew concerned and repeatedly called the police over the course of several days. Later that week, Durst reported his wife missing. Both the doorman and the building superintendent at the couple's apartment on Riverside Drive claimed to have seen McCormack at the building on the 1st of February, the day after she was last indisputably seen. The doorman additionally said that he'd only seen her from behind and from half a block away, and as a result, couldn't be certain that it was her. A private investigator hired by Durst's lawyer later reported that the doorman said he had not seen McCormack arrive at all, and might not have even been working the night she disappeared. Only 3 weeks after Robert had reported his wife missing, the superintendent on Riverside Drive found some of her possessions in the building's trash compactor. 3 weeks before her disappearance, McCormack had been treated at the Bronx Jacobi Medical Center for facial bruises. She told a friend that Durst had beaten her, but didn't press charges of the incident. She then asked Durst for a $250,000 divorce settlement. Instead, he cancelled her credit card, removed her name from the joint bank account, and refused to pay her medical school tuition. At the time of her disappearance, Durst had been dating Prudence Farrow, Mia Farrow's sister, for 3 years and were living in separate apartments. Durst initially offered $100,000 for his wife's return and then reduced the award to just $15,000. When one of McCormack's friends and a sister learned that she had been reported missing, they broke into a South Salem cottage hoping to find her. Instead, they discovered the residence ransacked, McCormack's mail unopened, and her belongings in the trash. After McCormack's disappearance, the NYPD said that Durst had claimed to have last spoken to her when she had called from the Riverside Drive apartment. He maintained that the last time he had seen her was at Catanoa Station, where she was planning to board a 9:15 p.m. train to Manhattan. He also claimed on the 4th of February, the supervisor at the medical school telephoned him to say that she'd been absent from class all week after calling in sick on the 1st of February. Whether McCormack herself had made that call is unknown. Durst divorced McCormack 8 years after her disappearance, claiming spousal abandonment. In 2016, her family asked to have Kathleen declared legally dead, a request that was granted the following year. Kathleen's mother, Anne McCormack, attempted to sue Durst for $100 million, alleging that he had killed her daughter and deprived her parents of the right to bury her. Her parents have now sadly passed away. Kathleen's younger sister, Mary McCormack Hughes, also believes that Durst murdered her. The New York State Police quietly reopened the criminal investigation into the disappearance in 1999, searching the South Salem cottage for the first time. The investigation became public in November 2000. In August 2019, a wrongful death lawsuit against Durst, filed by another of McCormack's sisters, Carol Belmonte, was dismissed on the grounds that she had waited too long to sue. In 2018, the US Court of Appeals had revised the date of McCormack's death to match the January 1982 day she disappeared. On the 17th of May, 2021, during Durst's trial for Berman's murder, Westchester County District Attorney Mimi Roker announced that McCormack's disappearance had been reclassified as a murder and would be reinvestigated. In October 2021, shortly after Durst's first-degree conviction in the Berman case, Westchester County prosecutors announced that they would impanel a grand jury to explore charges against Durst in the McCormack case. He was officially charged with her murder on the 22nd of August, 2021. Susan Berman, a longtime friend of Durst's, who had facilitated his public alibi after McCormack's disappearance, was the daughter of David Berman, a major Jewish-American organized crime figure who dominated illegal gambling in Depression-era Minneapolis and later took over the Flamingo Hotel and Casino on the Las Vegas Strip. On the 24th of December 2000, Berman was found murdered execution-style in her home in Benedict Canyon, Los Angeles, after her neighbors called the police to report that her door was open and one of her dogs was loose. A few days later, a letter addressed to the Beverly Hills Police Department, postmarked the 23rd of December, contained Berman's address and the word cadaver. On the envelope, Beverly was misspelled as Beverly. Durst is known to have been in Northern California days before her death and to have flown from San Francisco to New York the night before her body was discovered. Berman had recently received $50,000 from Durst in 2 payments. Although Durst confirmed to the LAPD that he had sent Berman $25,000 and faxed investigators a copy of a 1982 deposition regarding his missing wife, he declined to be further questioned about her murder. Durst said in a 2005 deposition that Berman called him shortly before her death to say that the LAPD wanted to talk to her about McCormack's disappearance. A study of case notes by The Guardian cast doubt on whether the LAPD had made such a call or whether then Westchester County District Attorney Jeanine Pirro had scheduled an interview with Berman at all. After being tipped off by his sister Wendy that the McCormack investigation had been reopened, Durst went into hiding and moved to Galveston, Texas, disguising himself as a mute woman to avoid police inquiries. Berman biographer Kathy Scott had asserted that Durst killed Berman because she knew too much about his wife's disappearance. Morris Jack Julius Black was born on the 21st of October 1929 in Malden, Middlesex County, Massachusetts, to Fagel Fanny and Samuel Black, and was one of 6 children. In childhood, he contracted polio and he would walk with a limp for the rest of his life. His parents suffered from mental problems and the children were placed in foster care. The siblings accused their father of sexual abuse, in which Morris allegedly participated. He joined the Merchant Marines at the age of 18, returning in the 1950s. In 1972, he became co-owner of a building near Boston Harbor. The city foreclosed on him in 1976, taking possession of the building. In 1980, he purchased the 3-story Boston tenement. Neighbors recall him as personally evicting a resident by force for dealing drugs, rather than calling the police. In late 1981, he rented the space from a barber shop and worked repairing watches. The following year, he returned to Boston. In 1987, he sold the tenement and moved south. From 1988 to July 1994, he lived in Galena Park, Texas. From September 1994 to June 1995, he lived in Long Beach, Mississippi. On the 6th of October 1997, he was arrested in North Charleston, South Carolina, after a telephone dispute over a $50 bill in which he threatened to blow up a South Carolina electric and gas company. He spent the night in jail and was convicted of a misdemeanor and sentenced to community service. After a time living in Brownsville in October 1998, he moved to Galveston. In November 1999, he moved into his final residence on Avenue K. On the 15th of November 2000, Galveston landlord Klaus Rien Dillman was contacted by telephone by a man claiming to serve as an aide to a deaf-mute woman named Dorothy Sinner. On the 9th of October 2001, Durst was arrested in Galveston shortly after body parts belonging to his then elderly neighbour, 71-year-old Morris Black, were found floating in Galveston Bay. Durst was released on a $250,000 bail and missed a court hearing on the 16th of October, and a warrant was issued for his arrest on a charge of bail jumping. On the 30th of November, he was caught inside a Wegmans supermarket in Bethlehem, Pennsylvania, after trying to shoplift Band-Aids, a newspaper, and a chicken salad sandwich, despite having $500 in cash in his pocket. Among the items discovered in his rental car were $37,000 in cash, 2 guns, marijuana, Black's driver's license, and directions to Gilbreth and Chami's home in Connecticut. He also used his time on the run to stalk his brother Douglas, visiting the driveway of his home in Catanoa, New York, while armed. He employed defense attorney John Waldron while he was held on charges in Pennsylvania. He was eventually extradited to Texas for trial. In 2003, he was tried for the murder of Morris Black. On the death of Black, the prosecution presented the jury with only a charge of capital murder with no lesser murder or manslaughter charges. Durst employed defense attorney Dick DeGuerin and claimed self-defense. DeGuerin conducted 2 mock trials in preparation for the case. Durst's defense team found communicating with him to be difficult and hired psychiatrist Milton Altshuter to investigate. After spending 70 hours examining him, Altshuter diagnosed Durst with Asperger's syndrome, stating, his defense team argued at trial that the diagnosis explained his behavior. Durst claimed that Black, a cranky and confrontational loner, grabbed his .22 caliber target pistol from its hiding place and threatened him with it. During the struggle for the pistol, the weapon discharged and shot Black in the face. During cross-examination, Durst admitted to using a paring knife, 2 saws, and an axe to dismember Black's body before bagging and dumping his remains in Galveston Bay. Black's head was never recovered, so prosecutors were unable to present sufficient forensic evidence to dispute Durst's account of the struggle. As a result of lack of forensics, the jury acquitted Durst of the murder on the 11th of November 2003. On the 21st of December 2004, Durst pleaded guilty to 2 counts of bail jumping and 1 count of evidence tampering for his dismemberment of Black's body. As part of a plea bargain, he received a sentence for 5 years and was given credit for time served, requiring him to only serve 3 years in prison. He was paroled in July 2005. The rules of his release required him to stay near his home. Permission was required for him to travel. However, that December, he made an unauthorized trip to the boarding house where Black was killed and to a nearby shopping mall. At the mall, he ran into former Galveston trial judge Susan Criss, who had presided over his trial. Due to this incident, the Texas Board of Pardons and Paroles determined that he had violated the terms of his parole and was returned to jail. he was released again from custody on the 1st of March 2006. Asked in March 2015 whether he believed Durst murdered Black, Chris commented, Private investigator Bobby Backer argues Morris Black had known Durst years prior and was likely involved in the disappearance of Durst's first wife, Kathleen, in 1982. Durst's notoriety inspired the 2010 film All Good Things, the title of which is a reference to the Vermont health food store of the same name set up by Durst and McCormack. David Marks, the character based on Durst, was portrayed by Ryan Gosling, and his wife Katie was portrayed by Kirsten Dunst. Shortly after its theatrical release, Durst contacted director Andrew Jarecki and expressed his approval of the film, which evolved into discussions between them of them being included in the DVD video release, and eventually resulting in Jarecki co-writing, co-producing, directing, and appearing in the 2015 documentary miniseries The Jinx, The Life and Deaths of Robert Durst, which was broadcast on HBO. During the production of The Jinx, Susan Berman's stepson uncovered a 1999 letter written by Durst which contained the same Beverly Hills typographical error as the anonymous letter directing police to Berman's body, implicating Durst in the murder. Jarecki and producers Mark Smerling and Zach Stewart Pontier realized they had uncovered potential criminal evidence and delivered the second letter to the Los Angeles County District Attorney's Office. The new information led to Durst's indictment for the first-degree murder of Berman. The FBI arrested Durst in New Orleans on the eve of the broadcast of the final episode of The Jinx. The Jinx ends with Durst moving into a bathroom, where his microphone records him seemingly saying to himself, "There it is, you're caught. You're right, of course, but you can't imagine the rest of them. I don't know what was in the house. Oh, I want this. What a disaster. He was right, I was wrong. And all the burping, I'm having difficulty with the question. What the hell did I do? Killed them all, of course." It later became known in 2019, the filmmakers altered the sequence of Durst's comments, increasing the apparent severity of his musings in the bathroom. In November 2023, HBO announced The Jinx Part 2, a 6-episode continuation of the series, was in production with the same producers and director, and premiered on the 21st of April 2024. Part 2 covers the 8 years between the original series in 2015 to present time, including new interviews, hidden material, and Durst's prison calls. On the 14th of March 2015, a few days after a first-degree murder warrant was signed by a Los Angeles judge alleging a role by Durst in relation to the Berman killing, Durst was arrested by FBI agents at the Canal Street Marriott in New Orleans, where he was registered under the false name Everett Ward. Durst, who'd been tracked to the hotel after making two calls to check his voicemail, was observed wandering aimlessly in the lobby and mumbling to himself, having driven to New Orleans from Houston 4 days before. In addition to a .35 caliber revolver loaded with 4 live rounds and 1 spent shell casing, police recovered 5 ounces of marijuana, his birth certificate and passport, maps of Louisiana, Florida, and Cuba, a flesh-toned latex mask, the fake Texas ID he used to check into the hotel, and cash totaling $42,631. Police discovered a UPS tracking number, which led to an additional $117,000 cash and a pair of shoes in a package sent to Durst by a friend in New York, which was seized after his arrest. Bank statements found in one of Durst's Houston condominiums revealed cash withdrawals of $350,000 in little more than a month. He's believed to have planned to flee to Cuba after the HBO documentary aired, since the US and Cuba have no extradition treaty. On the 15th of April 2015, New York State Police investigator Joseph Barreca, long involved with the McCormack case, and said to have been working closely with the FBI and Los Angeles detectives, removed around 60 file boxes of Durst's personal papers and effects from the home of Durst's friend Susan T. Giordano in Campbell Hall, New York. All of these items had been sent to Giordano for safekeeping 3 years prior by Durst's then-wife, Deborah Lee Charton. Also stored at Giordano's residence were videotaped depositions of Durst, his brother Douglas, and Charton, all of which were related to the Black case. Los Angeles County Deputy District Attorney John Lewis, in charge of prosecuting Durst, immediately flew to New Orleans after his arrest. With Durst's permission, Lewin interviewed him for 3 hours without a lawyer present. The recorded questioning was later introduced as evidence in the Berman trial. In regards to the investigation, Lewin claimed to have found information uncovered by the filmmakers, The Jinx, to be compelling and repeatedly flew to New York to interview witnesses, including friends of Durst and Berman's. On the 16th of March 2015, Dick Duguayren advised court authorities in New Orleans that Durst waived extradition and would voluntarily return to California. Later that same day, Louisiana State Police filed charges against Durst for being a felon in possession of a firearm and for possession of a firearm with a controlled substance, forestalling his immediate return to California. Orleans Parish District Attorney Leon Cannizzaro commented, in light of prior convictions that could influence Durst's sentencing, just for those gun charges here in Louisiana, Durst could face up to life in prison. On the 23rd of March, Durst was denied bail by a Louisiana judge after prosecutors argued he was a flight risk. In an effort to hasten his extradition to California and avoid a protracted court battle in Louisiana, Duguayren raised questions about the validity of the New Orleans arrest and hotel room search, observing a local judge didn't issue a warrant until hours after his client was detained. While communicating with the LAPD and conducting an inventory of Durst's hotel room possessions, the FBI held him there incommunicado for almost 8 hours. According to Duguayren, Durst was questioned extensively by a Los Angeles prosecutor and detective without a lawyer present on the morning after his arrest. In failing to produce the arresting officers subpoenaed for probable cause hearing, Durst's attorneys charged that Louisiana prosecutors engaged in a misguided attempt to conceal the facts from the court, the defendant, and the public. Peter Mansfield, an assistant U.S. attorney, said that his office instructed the 2 FBI agents and arresting officer not to appear, arguing that Duguayren subpoenas were issued in an attempt to conduct actions against them in their official capacities for the purpose of abstaining testimony, information, and material maintained under the colour of their official duties. On the 8th of April, a day after the U.S. Attorney filed an independent federal weapons charge, Durst was formally indicted by a Louisiana grand jury for carrying a weapon with a controlled substance and for the illegal possession of a firearm by a felon. Later that month, his lawyers requested that more than $193,000 seized by authorities during their searches to be returned, saying the cash is not needed as evidence, is not contraband, and is not subject to forfeiture. After negotiations with his defense team, Louisiana authorities ultimately dropped weapons charges against him on the 23rd of April 2015. His trial on the federal weapons charge was scheduled for the 21st of September 2015. Duguayren confirmed rumours Durst was in poor health, stating that he suffered from hydrocephalus and had a stent put into his skull 2 years before, as well as a spinal surgery and a cancerous mass removed from his esophagus. Durst's attorneys requested a later date for the federal weapons trial, saying that they would need more time to prepare after rulings on pending motions. U.S. District Judge Helen Barragan later scheduled the trial for the 11th of January 2016. On the 16th of November 2015, a New Orleans federal judge ordered Durst rearraigned on the weapons charge and scheduled the hearing for the 17th of December. When asked, his attorney said only that Durst didn't kill Berman and that he wanted to resolve the other charges to expedite Durst's extradition to Los Angeles to face that charge. On the 16th of December 2015, prosecutors and defense attorneys told Barragan in a joint motion that scheduling conflicts ruled out all dates before the 11th of January trial date. Barragan ultimately rescheduled the trial for the 3rd of February 2016, and Durst changed his plea to guilty to the federal gun charge and received an 85-month prison sentence. Durst's trial concerning the Berman killing was scheduled to begin in Los Angeles after Durst was arraigned in California, but his transfer was delayed by the U.S. Bureau of Prisons due to serious surgery, according to Duguayren. A conditional hearing was convened in February 2017 where Nick Chavin, a close friend of Durst's, and whose wedding Durst served as best man, testified that Durst had personally confided to having murdered Berman. A preliminary hearing was initially scheduled for October 2017, but was postponed to April 2018 to accommodate Durst's defense team, some of whom had suffered damage to the homes and offices from Hurricane Harvey. The pre-trial hearings included extensive testimony from a number of older witnesses who potentially would not be available when the trial itself began. In October 2018, Los Angeles County Superior Court Judge Mark Windham ruled that enough evidence existed to try Durst for the murder of Berman and that he would be arraigned on the 8th of November 2018. During his court appearance the following day, Durst pleaded not guilty. In January 2019, Windham set Durst's trial date as the 3rd of September 2019. At the same time, Judge Wyndham ruled that prosecutors would present evidence involving the Black murder. Prosecutors would try to connect Berman's murder with McCormack's disappearance, which they argued was the foundation for the motive of the murder. In his ruling that prosecutors could use evidence from the Texas case, Judge Wyndham said that the killings of Black and Berman seemed to be intertwined. The murder charge against Durst included the special circumstance allegations of lying in wait and killing a witness to a crime. It was further alleged that Durst had used a handgun to carry out the murder. In May 2019, a motion filed by Durst's attorneys claimed 2 handwriting samples, the anonymous cadaver note to Beverly Hills Police, and a letter in 1999 obtained from Durst to Berman, along with other evidence from his 2015 arrests, were obtained in violation of the Fourth Amendment, thus moving for their exclusion. On the 8th of May, Los Angeles County prosecutors filed an affidavit replying to the motion, charging that Durst was creating an elaborate conspiracy theory between the HBO filmmakers, law enforcement officers, and the Los Angeles County District Attorney Office to make Durst incriminate himself. On the 17th of May, Wyndham granted Durst's defense team a 4-month postponement of the trial after they raised concerns about the volume of evidence in the case that conflicts with attorney schedules. On the 3rd of September 2019, Wyndham rejected an attempt by Durst's attorneys to strip the prosecutors of the jinx of protection under the California's Journalist Shield Law by having them declared government agents. A number of other procedural rulings also went against Durst. Lewin set another hearing on discovery and other matters for the 28th of October. Additional evidential hearings were held in December 2019 regarding the admissibility of statements Durst made in March 2015, just after his arrest in New Orleans, in an interview with Lewin. In a surprise move, on the 24th of December 2019, Durst's lawyers contradicted his previous statements and filed court documents admitting that Durst wrote the cadaver note. In all previous statements, Durst consistently had denied writing the note, although the handwriting appeared to be similar to his own, as the misspelling of the word Beverly contained in the prior letter to Berman that Durst admitted to authoring. During the filming of The Jinx, Durst told filmmakers that the person who wrote the cadaver note was taking a big risk because it was something that only the killer would have written. He told his godson, Howard Altman, the person who wrote the note killed her. However, in August 2019, his attorneys also argued what the note demonstrates is that the person who mailed it was aware that there was a body at the house, not that the individual murdered Susan Berman. On the 2nd of March 2020, he appeared in court to begin his trial, which was expected to take several months. However, the proceedings were postponed amid the pandemic. In June 2020, a motion by the defence for the mistrial cause of the delay was denied. The following month, Wyndham ruled that a further delay until April 2021 was necessary due to the pandemic, but would allow the trial to proceed if Durst agreed to a bench trial without a jury. Durst declined this option, and the trial was scheduled to resume on the 12th of April 2021. It was then postponed until the 17th of May 2021. On the 13th of May 2021, his lawyers filed a motion with the court saying that he developed bladder cancer and moved that the court postpone the trial indefinitely and to release him on bail to receive medical treatment that was currently being provided. The motion was denied by the court and the trial resumed on the 17th of May, with Wyndham questioning jurors about whether they could still remain neutral in a case after a 14-month break. On the 10th of June 2021, Durst was hospitalised after being found down and not in his wheelchair. Wyndham sent the jury home with plans to resume on the 14th of June. Lewin expressed suspicion that the defendant was faking a medical crisis to force a mistrial because he was, on record, in his calls from county jail saying that he intended to feign dementia or seek a mistrial due to COVID-19. I have no idea whether this is legitimate or not, but obviously, given his history, it's certainly suspect as to what his actual condition is, Lewin said. Noting that Durst's lawyers had twice sought mistrials during the previous day's testimony, the prosecutor added, "It's very clear that the defence and the defendant want this trial to go away." Jail doctors determined Durst was able to appear in court after an emergency hospitalisation, which was for a urinary tract infection and sepsis, and Wyndham reconvened the trial on the 14th of June. Durst was unable to dress himself and was in court in his wheelchair, jail uniform, with a catheter bag and covered in a large blanket. As testimony continued, his brother Douglas appeared as a prosecution witness on the 28th of June 2021, saying that he was reluctant to appear at the trial and was doing so under the threat of subpoena. Douglas was asked about his relationship with his brother. On the 29th of June 2021, Durst's defence team asked again for an emergency halt to the case based on his poor medical condition, saying that he wasn't able to testify on his own behalf, but was again rejected on the 2nd of August, with Wyndham giving numerous examples of Durst's competency. The prosecution closed this case against Durst after 11 weeks of presenting evidence, preliminary consisting of friends and associates of Berman saying that she told them she was the alibi for Durst when his wife disappeared, and that he'd done something and she needed to do something as well. Shavin tasted that Durst told him, "I had to, it was her or me, I had no choice." The defence opening case with extensive testimony from false memory expert Elizabeth Loftus, questioning the decades ago recollections of prosecution witnesses. Although highly unusual for a murder case, Durst himself was expected to testify on his own behalf on the 5th of August 2021. The court was adjourned until the 9th of August due to a positive COVID test of a relative of Durst's legal team who had been attending the trial. Durst appeared on the stand for 14 days under questioning from Levin, who gave seemingly endless examples of Durst's prosperity to lie. Lewin concerned Durst to the point he admitted lying while under oath in the Morris Black trial in 2003, and that he lied 5 times whilst on the stand in the present trial. Durst and Loftus were the only witnesses the defence called. On the 14th of September 2021, the jury was charged with reaching a verdict by Judge Wyndham. On the 17th of April 2021, the jury convicted Durst for the first-degree murder of Susan Berman. Durst thus faced the possibility of a life sentence. He was also found guilty of multiple special charges. His lawyer said that they were disappointed and would pursue all avenues of appeal. On the 24th of September, his lawyers filed a motion with Wyndham to request a new trial. The reasoning was basically the same as they gave in Durst's trial defence. No physical evidence was presented, witnesses for the prosecution were not to be believed, and that the entire prosecution case was nothing but an unproven theory. On the 14th of October 2021, Durst was sentenced to life imprisonment without the possibility of parole for Berman's murder. The request from Durst for a new trial was denied by the court in view of the abundance of evidence of Durst's guilt. Following the murder conviction, Durst's legal team immediately filed appeals in the California legal system. As such, his appeals may be dismissed by the California Court of Appeal as the conviction set aside, as his death prevented the appeals from being heard. Days after the Berman murder, police were reportedly examining connections between Durst and the disappearances of 18-year-old Lynn Schluse from Middlebury, Vermont, and 16-year-old Karen Mitchell from Eureka, California. Investigators were also considering a possible connection between Durst and the disappearance of 18-year-old Kristen Modrefi, who was last seen in San Francisco in 1997. Schluse, a Middlebury College freshman, visited Durst's health food store on the 10th of December 1971, the day she disappeared, and was last seen that afternoon near a bus stop across from the store. Author and investigative journalist Matt Birkbeck reported in 2003 and again in his 2015 book, A Deadly Secret, that credit card records placed Durst in Eureka on the 25th of November 1997, the day Mitchell vanished. She may have volunteered in a homeless shelter that Durst frequented. Durst, dressed in women's clothing, had visited the Eureka shoe store owned by Mitchell's aunt. Mitchell was last seen walking to work from her aunt's store and possibly speaking to someone in a stopped car. A witness sketch of Mitchell's presumed abductor resembles Durst. Although the FBI ultimately couldn't connect Durst to the Long Island serial murders, in which some victims were disposed of in a similar manner to the Black killing, the Bureau created an informal task force in 2012 to work with investigative agencies in jurisdictions where Durst was known to have lived in past decades, including Vermont, New York, and California. In the wake of his arrest, the FBI encouraged such localities to re-examine cold cases. Texas private investigator Bobby Bakker also traced Durst operating under stolen identities in Texas, Florida, Massachusetts, New Jersey, South Carolina, Mississippi, and Virginia. On the 11th of December 2000, shortly before the Berman killing, Durst married Deborah Lee Charton, According to the New York Times, the couple had briefly shared a Fifth Avenue apartment in 1990, but have never lived together as husband and wife. Durst once told his sister Wendy that it was a marriage of convenience. I wanted Debbie to be able to receive my inheritance as I intended to kill myself, Durst said in a 2005 deposition. When Durst was arrested for the Black killing in 2001, Chatton wired him the $250,000 bail the court required. She also visited Durst in jail and spoke with him on the phone on a regular basis, discussing his legal strategy and other personal and business issues. Following the Black trial, Chatton reportedly distanced herself from Durst and his affairs, legal and otherwise. In particular, she specifically told Durst not to get involved with the Jinx, to which he disagreed at the time. Her friend said that after Durst's arrest in 2015, she hadn't spoken with him since the documentary had begun airing in February. Despite still being married to him, she was reported to be living with Stephen I. Holm in 2015. Holm was a real estate attorney in the New York City area who handled transactions for both Durst and Chatton. It was reported in Real Estate Weekly that Holm died on the 17th of October 2019 and that Chatton was his wife. Chatton was called Holm's wife at his funeral, in his obituary online, and in the obituary in the New York Times. Shortly after, Chatton sent the Times a letter saying that she and Holm weren't married and asked them to print a retraction. She and Holm were involved with several philanthropic ventures together. Shortly after Durst was convicted of murdering Berman in September 2021, a lawyer for the family of Kathleen McCormack sent Manhattan District Attorney Cyrus Vance Jr. a letter claiming the marriage between Durst and Chatton was a sham, solely to aid and abet Durst's financial crimes and murders, and to conceal those acts and frustrate investigators. The letter asked Vance's office to investigate these claims and also the issue of Durst being a bigamist because of Chatton's publicly claimed marriage to Holm. The letter was the second time the McCormack family asked the Manhattan District Attorney's Office to look into these issues, the first time being in March 2020. Durst travelled and lived under dozens of aliases over the years, using different identities to buy cars, rent apartments, and open credit card accounts. He had a scanner, copier, and a laminating machine, a former office employee of Durst told Newsweek. What I didn't realise was that I unwittingly saw what would have allowed Robert Durst to make a fake driver's licence. Durst was a prolific user of private mailboxes and apparently conducted business under a number of canine-themed names. Woofing LLC, Woof Woof LLC, and Igor Fayette Inc. In the early 1980s, Durst owned a series of 7 Alaskan Malamutes, all of which were named Igor, and all died under mysterious circumstances according to his brother Douglas. In December 2015, prior to the airing of The Jinx, Douglas told The Times, "In retrospect, I now believe he was practicing killing and disposing of his wife with those dogs." Durst was once recorded saying that he wanted to Igor Douglas. Durst, however, has disputed the assertion that he owned 7 dogs named Igor. He owned 3, he said, one that was run over and another that died in surgery after eating an apple core, before the Igor that lasted forever. From 2015 on, Durst had a number of significant medical issues, including major surgeries for esophageal cancer, having a shunt installed in his brain for hydrocephalus, and cervical spinal fusion. When arrested in New Orleans in 2015, he was found to be in possession of a variety of medications, including the sleep aid melatonin, a muscle relaxant, and medications for high blood pressure, blood flow, and acid reflux. During the Berman murder trial, his lawyers told the court that he had bladder cancer. On the 16th of October 2021, he tested positive for COVID and was placed on a ventilator. At his sentencing 2 days prior, his defense attorney, Dick DeGering, said Durst was in very bad condition, having a hard time breathing and speaking. It was unknown how Durst had contracted the virus and whether anyone else at the sentencing had been infected. In mid-2002, he signed over power of attorney to Chatton, and their holdings are thought to have remained closely intermingled. In 2006, he gave Chatton around $20 million of his $65 million trust settlement. In 2011, he purchased a $1.75 million townhouse on Lenox Avenue in Harlem. A source close to the Durst family confirmed that he was living there at least some of the time that they were keeping him under surveillance. He also owned 3 condominiums in a multi-story complex in Houston, and after a filing suit received a $200,000 settlement in 2006 from a Houston developer who refused to let him move into a unit newly purchased by his wife, which she had then immediately resold to Durst for $10. At the time of Berman's murder in Los Angeles, Durst had just sold a home in Trinidad, California, and maintained an office in Eureka whilst renting in nearby Big Lagoon. Media outlets variously reported Durst's financial status as real estate baron, rich scion, millionaire, multimillionaire, and billionaire. As of 2021, the Durst family real estate holdings are worth more than $8 billion, but Durst's brother Douglas has been in control of the Durst organization since the early 1990s. From around 1994 to 2006, Durst waged a legal campaign to gain greater control of the family trust and fortune. During that time, he received $2 million a year from the trust. In 2006, the case was settled, with Durst giving up any interest in the family's properties and trusts in exchange for a one-time payment of about $65 million. How much of that went to legal fees and taxes is unknown. He remained active in real estate. He reportedly sold 2 properties in 2014 for $21.15 million after purchasing them in 2011 for $8.65 million. At the time of his 2015 arrest, the FBI estimated Durst's net worth at approximately $100 million. The New York Times estimated his net worth to be $110 million. On the 1st of May 2015, the New York Post reported that Douglas Durst had settled litigation against Andrew Jarecki, having confirmed that Robert Durst was the source of videotape depositions that appeared in the Jinx. Durst's disclosure apparently violated the terms of his 2006 agreement with the family, which had disbursed him a lump sum of the trust assets. Whether Jarecki confirmed Durst as a source was unclear. The New York Times reported in March 2015 that he was given unrestricted access to Durst's personal records, including the videotaped material, but the settlement paved the way for Douglas to reclaim as much as $74 million of his brother's assets, effectively freezing those assets pending court judgment. This would potentially affect Durst's ability to pay for high-caliber legal representation without tapping into real estate or other investments. The Post reported that Douglas was mulling his next move, but no legal action had been taken. In November 2015, McCormack's three sisters and then 101-year-old mother sued Durst for $100 million, citing his apparent role in a murder and his denial to the family of the right to sepulture, a New York law that grants immediate relatives access to a deceased person's body and the opportunity to determine appropriate burial. If successful, the lawsuit would have relieved Durst's estate of most or all of the fortune he inherited. McCormack's brother James had attempted in October 2015 to file a wrongful death suit against Durst on behalf of his mother, but was challenged by one of his sisters, who held her mother's power of attorney. On the 7th of December 2015, the same family members filed a suit asking the court to freeze Durst's assets. The McCormack family's attorney, Robert Abrams, called Durst the poster child for why courts block defendants from disposing of assets while civil lawsuits are pending. In July 2016, the family asked the Surrogates Court in Manhattan to declare that Kathy died on January 31st, 1982, when she was murdered by her husband, Robert Durst, so that the sepulture lawsuit would proceed. The court granted the request, and Kathleen was declared dead in absentia in 2017. In 2021, Durst was among those listed in the Pandora Papers leak, exposing the offshore sheltering of financial assets by hundreds of political, business, and celebrity people. In 2012 and 2013, his family members sought and received restraining orders against him, saying that they were afraid of him. He was then charged with trespassing in New York City for walking in front of townhouses owned by his brother Douglas and other family members. He went on trial and was acquitted in December 2015. The judge also vacated the 13 orders of protection his family members had taken out on him. In July 2014, he was arrested after turning himself into police following an incident at Houston CVS drugstore in which he allegedly exposed his genitalia without provocation and urinated on a rack of candy. He then left the store and casually walked down the street. He was charged with misdemeanor criminal mischief. In December 2014, he pleaded no contest and was fined $500. His lawyer, however, described the incident as a unfortunate medical mishap. A recording of the incident was released on videotape in 2015. Durst died of a cardiac arrest in the San Joaquin General Hospital in French Camp, California on the 10th of January 2022 at the age of 78. He'd been undergoing medical tests when he went into cardiac arrest and didn't respond to resuscitation. At the time of his death, he remained in the custody of the California Department of Corrections and Rehabilitation. In January 2022, McCormack's family filed a wrongful death suit against Durst's estate. This was the fourth similar civil suit the family had filed since 2015, attempting to claim all or part of Robert Durst's assets. In response, a federal judge in the Southern District of New York ruled that Durst's second wife and heir, Deborah Charton, may not do anything with his $100 million estate. The court documents say Charton and or her attorney must appear in court on the 25th of March 2022 and show cause why the order should not be issued. In March 2023, a federal court judge ruled that the case of wrongful death filed by Kathy Durst's family against the estate of Robert Durst could proceed. In this ruling, the judge wrote that the lawsuit filed was not ultimately because of Robert Durst's death. A conference was scheduled for April 2023. As of August 2025, the suit remains in the pre-trial phase, with active motion, practice and hearings taking place. No trial date has been set. Thank you for watching today's video. I hope you enjoyed. Are there any other true crime cases that you would like to see me cover on this channel? If so, let me know in the comments. What are your thoughts and opinions about this case? Also let me know in the comments. Thanks for watching, and I'll be back next Friday at 5 o'clock with another true crime case.